The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain depositions. We'll talk about what a deposition is, what to expect from a deposition, how to prepare for a deposition, and we'll also talk about what deposition testimony can be used for. But first, let's talk about what a deposition is. It's basically an on-the-record interview of a potential witness or one of the parties to the case, conducted by the opposing attorney. There will be a court reporter present to take a transcript, and all of the attorneys in the case will be present, and usually the parties to the case attend as well. It's usually conducted at the offices of one of the attorneys involved in the case. So let's talk about what happens during a deposition, what you can expect. This isn't supposed to be a gotcha moment for attorneys. It's information gathering. The attorneys will ask a series of questions to basically flesh out the witness's story and not be surprised by anything at trial. So they want to understand everything that the witness is going to say at trial and fully understand the witness's story. It's usually limited to 3 hours. It can go longer if the judge orders so, but usually it's limited to 3 hours. If it's a simpler witness in the case, someone who's not one of the star witnesses, it'll usually only take about an hour. In addition to questions about the witness's story and what they're going to say, the attorney conducting the deposition will often ask the witness to identify documents. So these will be the key documents that the witness has knowledge of. They'll be marked as exhibits by the court reporter and included with the transcript, so there's no confusion over which document the witness is talking about. And the attorney will ask the witness questions about the authenticity or the contents of the document. So the attorney conducting the deposition is allowed to follow any relevant line of questioning. It's a lot more broad than what is allowed to be asked at trial. So anything that's relevant to the case, the attorney is allowed to ask. If the other attorney objects to a question or instructs the witness not to answer a question, since there's no judge present, you might be wondering how are disputes resolved. So there's basically 3 ways that the attorneys can resolve the dispute. One is to do something called certify the question. So if the attorneys can't agree whether a question should be answered, they can basically have the transcript highlighted with a certified question, and the attorney conducting the deposition can later decide whether to file a motion to compel the witness to give testimony on that topic. The second way to resolve the issue, and this is not super common, but you can always call the judge's chambers, and have the judge decide whether the question needs to be answered right then and there. Finally, either attorney can terminate the deposition at any time. If the attorney who is not conducting the deposition terminates the deposition, they can go to court then and decide whether that attorney was correct in terminating the deposition. If not, the deposition will be resumed, and the party who terminated the deposition may have to pay the costs associated with the termination of the deposition. So after the initial line of questioning by the attorney conducting the deposition, again, this is the attorney that's adverse to the witness, the attorney on whose side the witness is going to be testifying can then ask a series of questions. This is called often rehabilitating the witness. So if the witness says some things that the attorney didn't like or thinks need clarification or walking back, then the attorney can ask questions that are related to the line of questioning that the adverse attorney originally followed. Then the adverse attorney, the one that conducted the bulk of the deposition, can ask a series of questions, again, about the questions that the favorable attorney was asking. So you basically get the adverse attorney asking questions, then the attorney on whose side the witness is testifying asking some questions relating to the adverse attorney's questions, and then the adverse attorney asks a third set of questions relating to the second line of questioning. And they've got to be, you can't bring up new things in the second and third lines of questioning. They have to be related to the previous lines of questioning. Again, I said these are limited to 3 hours, but 3 hours is a long time, so it's pretty customary to take a couple breaks, 5-10 minute breaks after each hour of questioning or whenever the witness needs it. This gives the witness and the attorney time to regroup. Both sides get to confer with the parties and touch base on things they might have been missing. So let's talk about what deposition testimony can be used for. many people don't understand this, but deposition testimony typically isn't just entered into evidence at trial. It's not used generally as a piece of evidence. It's generally used for information gathering so you can prepare for trial and know what the witness is going to say and know what questions to ask at trial. It's an old maxim that you're never supposed to ask a question at trial that you don't already know the answer to. However, if the witness gives a different answer at trial than they did at deposition, then the deposition transcript can be entered into evidence, or at least part of it can, for the purpose of impeaching the witness. This is basically saying, are you lying now or were you lying then when you gave this deposition testimony? And impeaching the witness is basically entering that evidence to hurt the credibility of the witness and show that they're lying either in their deposition or at trial. Another thing deposition testimony can be used for is preserving the testimony of witnesses. So if in certain situations, like when a witness dies after giving deposition testimony or is otherwise unavailable for trial, the deposition testimony can be entered as evidence and used basically as that witness's testimony. Courts don't like to do this unless it's absolutely necessary because the witness isn't able to be cross-examined on their testimony if they're not actually called to the stand. Finally, motions for summary judgment. Prior to trial, either side can file a motion for summary judgment, and this is a motion basically saying there's no dispute as to what the material facts are in the case. There's no genuine dispute as to the facts. So we don't need to have a trial because a trial is about finding out what the truth is for the underlying facts. We don't need to have a trial, and I, the movant, am entitled to judgment according to the law. So it's asking the judge to make a ruling on some or all of the claims in the case without having a full-blown trial. And usually the main thing that supports a motion for summary judgment is deposition testimony. And you can use the other side's deposition testimony, or the witnesses of the other side use their deposition transcripts to prove that everyone's in agreement on the facts, and based on what the other side thinks the facts are, you're still entitled to win the case. And so that's one thing that depositions are key for, is motions for summary judgment. So let's talk about how to prepare for a deposition. So before a deposition, the witness will usually meet with the attorney on whose behalf they're testifying. They'll review all the important documents in the case so they're not surprised by anything, refresh their memory of the important facts of the case and the timeline of what happened when, and make sure they have a clear understanding of the attorney's theory of the case. What are we trying to accomplish in order to win this case? You're not trying to change what the facts the witness is testifying to are, but understanding why their testimony is important to not giving bad testimony in a deposition. Let's talk about a couple tips for giving good deposition testimony. So we always tell clients to answer honestly. Don't stonewall the attorney asking the questions. Don't get confrontational, but don't answer more than is asked. People get into trouble when they start giving long narratives and are offering more than the attorney on the other side asks. You shouldn't give one-word answers that don't actually answer the question necessarily, but make the attorney work for the information that they're trying to get. Be polite. Again, don't be confrontational. This isn't necessarily like something you would see in the movies where the attorney is shouting at the witness and trying to get them in a gotcha question. There's just an information gathering exercise. Don't be confrontational, but stay on your toes. And if you don't know the answer to a question, don't guess. It's okay to say that you don't know the answer or to say that you don't remember. It's important that if the question that's being asked is going to be something that you're going to want to answer or talk about at trial, if you don't remember at the time of the deposition, there better be a reasonable explanation for refreshing your recollection when you're testifying at trial. So that's what you need to know about depositions. If you have any questions, you can give me a call at 630-324-6666 to schedule a free consultation. We offer consultations in nearly every area of law, and we have offices all around Chicagoland for your convenience. If you don't want to actually retain an attorney, but you just want some questions answered, you can leave a question below our post at learn-about-law.com in the comments section or below the video on our YouTube station, and we'll try to answer your question within a couple of days. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud, and you'll be notified of our daily article and video posts, and that's helpful to us as well. So thank you so much for watching.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.